The honourable member for Nelson.
President, I'm very pleased to be standing here speaking to this motion, and probably especially because of this motion, I'd like to start by acknowledging the Tasmanian Aboriginal community as the traditional and ongoing custodians of the land that we meet on today. I pay my respects to their elders past and present, and I would like to acknowledge that they never ceded this land on which we are standing. Mr President, I've moved this motion for debate because the federal government has proposed a piece of legislation which, if passed, would leave vulnerable Tasmanians with less protection from discrimination than they currently enjoy. The proposed legislation will do this by rendering a state law passed by this chamber no longer workable. In fact, the federal bill specifically targets our Tasmanian Anti-Discrimination Act 1998 with the intent of diminishing its protections. As citizens, as representatives of our community and as legislators for this state, this is a matter that deserves our attention. It warrants our discussion, and I believe it requires of us a clear statement of response. That is the purpose of this motion. Mr President, I ask that members here in this place join with me in considering a strong response to this proposed federal bill and the potential impact it holds for our state. Equality is important to me. Rights are important. From my work, which has focused on social justice for many years, I have an avid appreciation of the protections we put in place for those who are marginalised, stigmatised, discriminated against and vulnerable. Articulating and respecting rights assists us to live in a community that is fair and safe and inclusive. Putting in place discrimination law is one way that we do that. It's about ensuring equality. It protects all of us from the harms of discrimination and prejudice and requires all of us to behave in ways that promote the equality and the equal opportunity of all others. However, rights and equality are also about balance. Balancing some rights against each other and against protections from harm is an ongoing challenge and a matter of discussion for us as a community. I believe the proposed federal bill misses the mark on balancing rights and protections, and the potential negative impacts of that imbalance pose a danger to the Tasmanian and ultimately Australian communities. So I've brought this motion, Mr President, and the first point of that asks that the Legislative Council acknowledge that Tasmanians enjoy the strongest and most comprehensive anti-discrimination protections in Australia, and that the Tasmanian Anti-Discrimination Act 1998 sets a standard for protection that has fostered a fairer and more inclusive society that's applauded by other Australian states and territories and around the world. Our Anti-Discrimination Act came about as a result of over 20 years of committed advocacy, community consultation and political negotiation. It has earned its place in our justice system, and it has demonstrated value for many, many Tasmanians who have found a resolution to harmful discriminatory experiences. Mr President, Associate Professor Therese Henning, the Director of the Tasmanian Law Reform Institute, gave a speech last year on the 20th anniversary of the enactment of the Tasmanian Anti-Discrimination Act. In that speech, Associate Professor Henning noted the standing and success of our Act. She said, and I quote, "Since the Anti-Discrimination Act became law, most of us have come to understand, if we did not before, that attribute-based discrimination is a very real problem in Tasmania. That many of us have experienced discrimination that has blighted our lives, minimised our life choices and otherwise caused us serious distress. Many of us lived with discrimination and no possibility of remediation before the Anti-Discrimination Act was enacted." End of quote. And further in that speech, she also said, and I quote, "The Tasmanian Anti-Discrimination Act was lauded at the time of its enactment as world's best practice. One reason that it received such an enthusiastic response is that it was a late addition to Australia's anti-discrimination laws, which meant that we had the opportunity to learn from mistakes made in other Australian jurisdictions and from the problems that had been identified with Anti-Discrimination Act laws elsewhere. End of quote. Having recognised the quality and the positive impact of our Act, Associate Professor Henning went on to note the need for vigilance in preventing the erosion of the protections it provides. She said of the Act further, and I quote, "Our experience in this regard teaches us of the need to be vigilant in preventing the erosion of rights protection it provides, both directly in narrowing its scope and increasingly its exceptions, and indirectly through procedural and practice requirements that limit the Commissioner's and or the Tribunal's ability to apply the Act properly and in accordance with its original legislative intent." End of quote. Associate Professor Henning's exhortation to vigilance in protecting our Act was timely and highly relevant to the situation we find ourselves in today. Mr President, we find ourselves in a position of needing to strongly advocate to maintain the level of protection our Act provides to the Tasmanian people. One reason Tasmania is considered to have the nation's strongest anti-discrimination laws is because of Section 17. So I will speak now about the second point in the motion that I've moved. It asks the Legislative Council to support Section 17 of the Tasmanian Act, which prohibits any conduct which offends, humiliates, intimidates, insults or ridicules a person based on certain attributes including age, race, gender, disability, marital status, pregnancy, family responsibilities, gender identity and sexual orientation. Other Australian states in their anti-discrimination legislation do not have such an extensive list of behaviours as those that are covered under Section 17. It is this more extensive list in our Act that captures many of the discriminatory, harmful experiences in the daily lives of, for example, people with a disability or LGBTIQ+ Tasmanians. The wording of Section 17(1) reflects Section 18C of the Federal Race Discrimination Act. It covers the same offensive conduct, offends, humiliates, intimidates, insults or ridicules, except that 17(1) in our Act covers more attributes than simply race under that federal legislation. Section 17 protects Tasmanians who are vulnerable to hate, prejudice and stigma from being subjected to humiliating and intimidating language. The statistics tell us that of complaints made under Section 17(1) of the Tasmanian Act, over a third of the complaints are on the grounds of disability, another third are complaints on the grounds of race, gender and age. The remaining third of complaints are on the remaining 10 grounds in that Act, in that section. Complaints on the grounds of sexual orientation and gender identity make up 5 to 10% of complaints. The Tasmanian Anti-Discrimination Act is consistent and balanced. Section 17(1) has been well examined in this place and confirmed by this Parliament. Further to that, it has also been tested by the Supreme Court in 2018, and it was found by that court to not unduly impinge on freedom of religion or free speech and to be valid under the Australian Constitution. Justice Brett of that court made a careful, rigorous argument that freedom of religion and freedom of speech are not unfettered rights, and that the Tasmanian Anti-Discrimination Act strikes the right balance between these rights and the rights of citizens to live free from hate and vilification. Mr President, this motion states support for Section 17 in the face of a proposed federal bill that would render it unworkable and allow Tasmanians included in the attributes it covers to be humiliated, intimidated, insulted or ridiculed in the name of religion. Personally, Mr President, I would go much further than support of Section 17. I would add my gratitude and admiration for Section 17 and our Act, which I believe makes our state a kinder, safer, more mature and thoughtful place to live for all Tasmanians. I can also say that I hold great pride in Section 17 of our Act. I am proud that we lead the nation in best practice protections. I believe Section 17 has encouraged us to give more attention to dealing with issues such as bullying in our schools, in our workplaces, and sets as normal the expectation that we endeavour to be more thoughtful, moderate, and kinder in the way we interact with each other. Notwithstanding my gratitude, admiration, and pride, in this motion I ask my colleagues to join with me in supporting Section 17 of our Anti-Discrimination Act. The third part of this motion asks the Legislative Council to note that twice in recent years attempts have been made in this Parliament to weaken the protections available under Section 17 of the Anti-Discrimination Act to Tasmanians who are vulnerable to hateful, humiliating and intimidating language, and that both times this chamber said no, not least because the biggest proportion of complaints under Section 17 come from people with a disability. A similar proposal to the proposed federal religious discrimination bill came to this place most recently in 2017. In 2017, in the same way that this federal bill proposes to allow humiliating, intimidating, insulting and ridiculing language, if that language is in the name of religion, the state government brought a proposed amendment to our Tasmanian Act that sought to allow conduct connected to religious belief under both Section 17 and also Section 19 at the time, a section which relates to incitement to hatred. Those amendments to the Tasmanian Act were not supported by the Legislative Council in 2017. Other members will be much better placed to recall this period than I, as they were participants in those debates. At the time that those attempts were made, I was outside this chamber in other roles, which included working with and for some of the most vulnerable members of the Tasmanian community, many of whom were at risk of having their protections lessened under the amendments proposed. While I was able to see media reporting on the debates at the time and read Hansard after the fact, other members here who participated in those debates will know firsthand the significant distress caused by the proposal to weaken the protections available to a wide range of Tasmanian people, including those with a disability, women, Aboriginal Tasmanians, culturally and linguistically diverse Tasmanians, older Tasmanians, and gender and sexually diverse Tasmanians. My understanding is that distress was expressed to members in large numbers of letters and emails and other communications. Other members will be better placed to reflect those exhortations that this place, those who made exhortations that this place stand firm in defence of our state's robust and effective Anti-Discrimination Act. And stand firm you did. We now see a similar attempt to do at the federal level that which was attempted by the state government in times past. An attempt to privilege one group of people over all others in their licence to engage in discriminatory speech. While it is not in our power here to stop the progress of a federal bill, it is most certainly in our power to be staunch and consistent in expressing our denunciation of its impact on our state sovereignty and our Tasmanian community. Mr. President, the fourth element of this motion asks that the Council is concerned that the federal government wants to weaken the right of this Parliament to make human rights laws for Tasmanians by proposing a religious discrimination bill that will weaken Section 17 in the same way this chamber has refused to countenance. Concern, as a word used here, is a fairly mild term, I think, to use in this instance when we are talking about what could be seen as a challenge to the very foundation of our federation. The states, including Tasmania, created our federation. Our federal constitution allows the Commonwealth certain powers and confirms that states and territories undertake their role of governing for the good of their communities, including legislating in a manner reflective of the values and needs of those communities. In seeking to override the protections of our Tasmanian Parliament, in seeking to override the protections our Tasmanian Parliament has enacted against discrimination, the proposed federal bill could be seen to undermine our federation and the sovereignty of the Tasmanian Parliament to do its work of governing for all Tasmanians. I believe it's wrong for the federal government to be attempting to do this. Clause 41 of the proposed Religious Discrimination Bill 2019 specifically overrides every anti-discrimination law in this country. It allows people to make statements of belief that would otherwise amount to discrimination under the laws that it seeks to override. In the case of Tasmania's Section 17, under this federal bill, people would be able to make statements that insult, offend, ridicule and humiliate others if it is done as a statement of belief. In its submission made to the consultation process on the federal bill by Equal Opportunity Tasmania, on page 5, that submission says, and I quote, "The draft Religious Discrimination Bill 2019 is not particularly clear in defining what is meant by a statement of belief. Clause 5 of the bill provides a statement of belief is a statement of a religious belief. Religious belief is defined to mean holding a religious belief. This is not helpful drafting." End of quote. Mr President, I agree with Equal Opportunity Tasmania on that assessment. That is not helpful drafting. We can contemplate illustrative examples of this override in a submission to the consultation on the federal bill that was made by Associate Professor of Constitutional Law at Monash University, Luke Beck, a leading expert on religious freedom and the Australian Constitution. On page 7 of his submission, Associate Professor Beck says, and I quote, "For example, in none of the following scenarios involving a statement of belief would the person on the receiving end of the statement of belief be able to lodge a discrimination complaint. An employer tells a gay worker, being gay is a form of brokenness. A school principal tells a school assembly, trans people choose to reject God's nature. A childcare provider tells a single mother, God will judge you harshly for taking away the child's right to have a father. An employer points at a Catholic worker's desk to a small picture of the Virgin Mary and says, look at that Catholic superstitious nonsense. An employer refers to a male Sikh employee wearing a turban as a towel head. A doctor tells a gender non-conforming patient that God condemns your sin. An employer tells a female worker that women should not be in positions of leadership over men. A cafe owner tells a customer with a disability that disabilities are God's punishment for sin. A pharmacist tells a Muslim customer, all Muslims will go to hell. End of quote. No other discrimination act, state, federal or territory, operates in this way of overriding protections that we have right now against statements of that sort. Since the passage of the first anti-discrimination acts in this country, the Commonwealth Racial Discrimination Act in 1975, the New South Wales Anti-Discrimination Act of 1977, all discrimination laws have operated effectively alongside each other without directly interfering with each other. This bill seeks to undermine and change that, and I think it undermines and changes every piece of protection we have in this country and also the way we operate as a federation. Further, and again from the submission by Equal Opportunity Tasmania made on the Federal Religious Discrimination Bill, on page 4 of that submission, and I'm going to quote, it's quite a lengthy quote and I think it's quite pertinent. The submission says, currently, Australian anti-discrimination law operates so Commonwealth and state anti-discrimination legislation works concurrently together and neither overrides the other. For example, Section 13 of the Disability Discrimination Act 1992, Commonwealth, states this Act is not intended to exclude or limit the operation of a law of a state or territory that is capable of operating concurrently with this Act. There are similar provisions in the Sex Discrimination Act 1984, Commonwealth, the Age Discrimination Act 2004, Commonwealth, and the Racial Discrimination Act 1975, Commonwealth. The equivalent provision in the draft Religious Discrimination Bill 2019 has the note, "Nothing in this subsection detracts from the operation of Part 4. Part 4 of the draft Religious Discrimination Bill 2019 is the part relating to statements of belief. This would have the effect that a statement of belief retains priority over all other discrimination laws. This is contrary to established discrimination law principles and contrary to the principles of human rights being equal. I note that recommendation 3 of the Religious Freedom Review brackets report of the expert panel dated 18 May 2018 close brackets recommended that anti-discrimination legislation reflect the equal status in international law of all human rights, including freedom of religion. The draft Religious Discrimination Bill 2019 goes against this recommendation and gives statements of belief unequal and priority status." End of quote from that submission from Equal Opportunity Tasmania. The protections, Mr President, provided to the Tasmanian people in our Anti-Discrimination Act were not arrived at in a quick or simple process. It required time and effort, political will, and a great deal of consultation with the community to deliver us that legislation. I ask that we stand again as representatives of the Tasmanian people and make a clear statement that it is unacceptable overreach for the federal government to try and run roughshod over our community and our right as a state parliament to legislate in the best interests of that community. Mr President, the fifth point of this motion asks that the Legislative Council note that the proposed federal government religious discrimination bill will make Section 17 of the Tasmanian Act unworkable, so that it would no longer offer the protections we currently enjoy. The proposed federal bill singles out Tasmania's anti-discrimination legislation and specifically Section 17. It's noted in the bill itself and with the clear intention to render it unworkable. The effect of this will be that the Tasmanian people will lose discrimination and hate speech protections, including people with a disability, LGBTIQ+ people, women, members of racial and religious minorities, people in unmarried relationships and single parents. In the submission from Equal Opportunity Tasmania, Tasmania's Anti-Discrimination Commissioner makes the case for this being a severe limit on access to justice. On page 5 of that submission, under the heading Overriding State Law, it says, and I quote, this is from the Tasmanian Anti-Discrimination Commissioner, "I strongly oppose the draft Religious Discrimination Bill 2019 overriding state discrimination law as, for the reasons given below, it curtails state sovereignty, diminishes existing human rights protections and will severely limit access to justice. I note the Commonwealth Attorney-General's public assurance that the draft Religious Discrimination Bill 2019 is not intended to displace state law. Yet, contrary to established discrimination law principles in Australia, the draft Religious Discrimination Bill 2019 explicitly displaces and overrides state law. The Anti-Discrimination Act 1998, Tasmania, is legislation passed by the Tasmanian Parliament to protect Tasmanians. In 2017, the Tasmanian Government attempted to exempt religious speech from the operation of Section 17(1) of the Anti-Discrimination Act 1998, TAS. Community groups in Tasmania, in particular groups representing people with a disability, gave information to the Tasmanian Parliament about how vulnerable Tasmanians would be negatively impacted by the state allowing offensive, humiliating, intimidating, insulting conduct to be directed towards them under the guise of religion. The quote continues, "The Tasmanian Parliament maintained the protections in the Anti-Discrimination Act the Tasmanian Parliament maintained the protections in the Anti-Discrimination Act 1998, TAS. It would be wrong for the Commonwealth to override the decision of the Tasmanian Parliament that Tasmanians should be protected from discrimination and offensive, humiliating, intimidating, insulting and intimidating conduct. The explanatory notes for the exposure draft of the Religious Discrimination Bill 2019 state at paragraph 422 that Section 17(1) of the Anti-Discrimination Act 1998 TAS should be overridden due to its broad scope and demonstrated ability to affect freedom of religious expression. This statement is not correct. The practical effect of Clause 41, brackets read in conjunction with the note to Clause 60, close brackets, of the draft Religious Discrimination Bill 2019 will be that when a respondent to a complaint under the Anti-Discrimination Act 1998 alleges they made a statement of belief, the complaint would fail. This would significantly impact access to justice. That's the end of the quote from that submission. The submission went on to explain that the Religious Discrimination Bill to be enacted, Clause 41 of that bill would provide a defence to complaints made under our Anti-Discrimination Act. Mr President, that defence under federal law would mean that the Tasmanian Anti-Discrimination Tribunal would have no jurisdiction to deal with the complaint. The Equal Opportunity Tasmania submission then provides some examples of instances in which this lack of jurisdiction would mean that access to justice would be lessened for Tasmanians. Those examples can be found on page 9 of the submission and they include a situation of a man sacked because he was living with his de facto partner, a child with a disability being bullied at school, and misogynistic behaviour towards women. It makes the point that of those examples, none of them would have access to justice were the federal Religious Discrimination Bill to provide a defence of those things being statements of belief. The submission points out, and this is just one further quote from it because it's very relevant to this part of the motion, and I quote, "If the draft Religious Discrimination Bill 2019 was law, that type of complaint would not be able to be dealt with under the Anti-Discrimination Act 1998, Tasmania. Preventing complaints being dealt with under the Anti-Discrimination Act 1998, TAS, where a respondent alleges they were making a statement of belief would restrict access to justice for people. Similarly, the Australian Human Rights Commission in its submission considers that this overriding of all other Australian discrimination laws is not warranted and it sets a concerning precedent." Associate Professor Luke Beck, the constitutional and religious freedom expert from Monash University, in his submission warned the Coalition's exposure draft bill may be incompatible with international law and therefore not supported by the external affairs power in the Constitution. International human rights law requires that people are treated on an equal footing under human rights laws. The proposed federal bill treats people differently. It gives people who hold a religious belief more rights than people who don't. Under this bill, people who hold religious beliefs can make statements on any topic. Then those statements can insult, offend, ridicule or humiliate other people if those statements are based on a claimed religious belief. For non-religious people, they are only protected in this way for statements on the topic of religion or for statements that arise directly from their non-belief. Given this inconsistency in treatment, it's likely that this proposed bill is inconsistent with international human rights law, and as such it's likely unconstitutional in its function of overriding state laws. I'll move on to the sixth point in this motion, which asks that the Legislative Council is concerned about other provisions of the Religious Discrimination Bill that appear to allow bullying and abusive statements in the workplace and in classrooms, and discrimination in the provision of healthcare and in the provision of other services. Protecting one group from discrimination should not extend to allowing that group to harm others. The protections for vulnerable groups under Tasmania's Anti-Discrimination Act were, in most cases, hard-fought gains in safety and opportunity, won over long periods of time in which those groups suffered the deplorable and harmful impact of unconstrained discrimination. That discrimination has not magically disappeared in its entirety, but those vulnerable groups now have a legislative protection and a recourse to seek a resolution when discrimination is experienced. To turn around now with this proposed federal bill and undermine that protection and take away the avenue for recourse by rendering it unworkable is wrong. Particular concerns have been raised that the discrimination based on religious belief allowed under Clause 41 in the proposed bill will be given licence in a range of settings, such as workplaces, schools, healthcare and other service provision. Women's Health Tasmania have raised this in an email correspondence which I believe other members may also have received. In that they said, and I quote, "The list of everyday situations where people could be subjected to these unprovoked judgments on the basis of who they are is potentially endless. The list of groups who could be adversely affected is almost as long. But their options to seek redress will be short. They would no longer be able to seek the support of the Australian Human Rights Commission or state and territory discrimination bodies, nor would employees be able to access the Fair Work Commission on these matters, on the Fair Work Commission," end of quote. Mr. President, if we can first consider the potential impact in workplaces. Currently, work health and safety laws impose a positive duty on employers to prevent bullying, and discrimination laws require businesses to provide their services free from discrimination. Yet, Clause 41 would authorise some forms of bullying and discrimination. A range of legal academics, the Diversity Council and others have warned that the Coalition's proposed religious discrimination bill is unworkable for employers and will thwart policies designed to create safe and inclusive workplaces. Indeed, the Australian Industry Group have made a submission to the consultation process on the proposed federal bill, and they have warned that the bill bans employers from setting codes of conduct which indirectly discriminate on the grounds of religion and could come into conflict with policies designed to promote tolerance and diversity in workplaces. The Australian Industry Group warned that the bill could, and I quote, "limit the ability for employers to regulate, respond and manage instances of inappropriate conduct by an employee that may cause conflict with or detriment to co-workers, notwithstanding that such conduct may occur when an employee is not performing work," end of quote. They also went on to say, and I'll quote some more, "The potential," this is from the Australian Industry Group submission, "the potential for the provisions of the proposed legislation to be used to advance and protect extremist opinions or behaviour of whatever kind in the name of an undefined religious belief should not be underestimated. The provisions of the bill as drafted would seriously impede the ability of employers to maintain appropriate standards of conduct and to protect their employees from harassment and discrimination." In its submission, the Australian Industry Group said that the draft bill, as well as being inconsistent with existing workplace laws, was, and again I'll quote their exact words, "unbalanced, unworkable and unfair upon employers," end of quote. They did note that over time, the courts have developed principles about where and when employers could regulate their employees' actions outside work, and the proposed laws would disturb these principles in a major way and had the potential to increase conflict and disharmony in Australian workplaces. And quite frankly, I'm not even going to spend very much time here on the slightly bizarre specific provision for companies with revenue of more than 50 million, which stops the sacking of employees for expressing religious views unless they're able to show that the action was necessary to avoid unjustifiable financial hardship. That is a situation where the protection of a right being asserted can apparently be traded off against financial hardship, and it does not seem to be at all consistent with an accepted international approach to human rights. I would like to move on, though, to look a little bit at the healthcare area. Mr. President, this proposed bill effectively puts the personal religious views of a health professional before patient need. It risks creating considerable complexity and uncertainty for health services. Under this law, it would be easier for doctors with objections to use their religious belief as a reason to refuse to provide care to a patient, and additionally to potentially refuse to provide information or referral to unbiased advice and care elsewhere. A particular risk is posed to health services such as abortion, euthanasia, contraception and sterilisation. In a debate at the National Press Club last week, Fiona Patton, in her role as an ambassador for the National Secular Lobby, said, and I quote, "Consider a midwife refusing to deliver a single mother's baby, a rural pharmacist refusing to fill a teenage girl's prescription for the pill, or a Christian nurse simply refusing to treat a Muslim. Bizarrely, the bill does not offer non-religious health practitioners the same right, even though they may hold the same beliefs." End of quote. This issue of conscientious objection is outlined in the Equal Opportunity Tasmania submission on the federal bill on page 3 of that submission. Under the heading, under clause 8, 5 to 6, conditions that are not reasonable relating to conscientious objection by health practitioners, it says, and this is a slightly lengthy quote that I'll read in, Clause 8.5 of the Draft Religious Discrimination Bill 2019 provides that where state or territory law provides for conscientious objection, a rule that restricts or prevents a health practitioner from conscientiously objecting is deemed not to be reasonable, and the rule will amount to indirect religious discrimination. Clause 8.6 of the Draft Religious Discrimination Bill 2019 provides that where state and territory law does not make provision for conscientious objection, a rule that restricts or prevents conscientious objection will be deemed to be not reasonable unless the rule is necessary to avoid an unjustifiable adverse impact on the provision of the relevant health service or the health of a person who is seeking that health service. The effect of Clause 8.6 is to potentially make unlawful a health service provider's rules relating to health practitioners undertaking procedures, providing information, prescriptions or referrals. This would result in patients losing the ability to access medical procedures or obtain information, prescriptions and referrals. In my view, it would be against the public interest to prioritise a person's religious belief over another person's right to access healthcare. End of quote. That was the view shared by Tasmania's Anti-Discrimination Commissioner in the submission from Equal Opportunity Tasmania. I would also refer here to the Victorian Equal Opportunity and Human Rights Commission submission to the consultation on the federal bill. They also raised significant concerns about this aspect of the proposed bill. On page 6 of their submission, and I'm going to quote some material from that. Further, Clause 8.6 does not set out any other obligations to patients, such as the provision of information, the requirement to disclose the objection, and the making of an effective referral. The absence of real consideration for patient care and well-being is a concern to the Commission, particularly given research has demonstrated ongoing compliance challenges for doctors with their existing legal obligations for conscientious objection to abortions in Victoria. In practice, these provisions will lead to confusion for patients, health practitioners and services, as well as have a negative impact on service quality. Even where state and territory legislation provides for effective referrals, the lack of clarity about the operation of conscientious objections can create uncertainty and avoidance in patients, particularly those from marginalised backgrounds who may have experienced stigma in mainstream health services. An absence of clear guidelines means a patient may be disrespected by a clinician, not provided a health service, information, a prescription or referral, and the health organisation is unaware as there are no reporting requirements on the health practitioner. The Commission is concerned that the applicability of Clause 8.6 is unclear and could undermine efforts by employers and health professional bodies to set standards and clarify legal obligations to ensure the provision of safe, inclusive and quality health services particularly in rural and remote areas. It may also create resource implications for specialist services, such as trans and gender diverse health services, as patients feel unsafe accessing mainstream health and GP services." End of quote. I share the concerns of both the Equal Opportunity Tasmania and the Victorian Equal Opportunity and Human Rights Commission that they've expressed around the impact on the provision of healthcare from this bill. The final area I wanted to speak briefly about was faith-based organisations and businesses, which was again raised as a matter of concern under this bill. The proposed bill could allow religious institutions, schools, charities and businesses to be made exempt from engaging in discriminatory practice under other state and Commonwealth discrimination laws, including ours, especially in relation to employment and the provision of goods and services. Equal Opportunity Tasmania again raises concerns about this. They talk about the clauses under which the Religious Discrimination Bill exempts a religious body for conduct carried out in good faith that reasonably conforms to its doctrines, tenets, beliefs or teachings. Clause 10 would cover a broad range of conduct, they say. Clause 10.1 states that the clause applies to conduct that may reasonably be regarded as being in accordance with religious beliefs. This broad approach would capture a wide range of conduct, so long as it had some connections with religious belief. They say in their submission, further, the definition of religious body set out in clause 10.2 is extremely broad. The broad definition of religious body could have the consequence of permitting discrimination in a wide range of areas, including schools, charities, hospitals and aged care homes. I know that when this place debated proposed amendments to the Tasmanian Anti-Discrimination Act in 2017, there was much discussion about the definition of a religion and the wide range of faith groups that may be captured by that definition and as such be protected and their actions sanctioned under the amendments to the Act. Similarly, this proposed federal bill in its definition of a religious body could cover a very wide range of workplaces and services. The final bit I'd like to speak about is women in particular here. I'd like to particularly mention women here as a group at risk of being made more vulnerable under this proposed bill. Vulnerable to healthcare and services being withheld, and vulnerable to damaging, intimidating and offensive comments and behaviours. The Victorian Equal Opportunity and Human Rights Commission has warned in its submission that this bill would mean that religious believers could be free to publicly shame rape survivors, and an unmarried woman would be powerless to seek redress if a doctor told her she was sinful and dirty for requesting contraception on the basis of a religious conviction. The Victorian Commissioner also noted that a clause in the draft bill stating that expressions of belief should be protected from anti-discrimination laws could have the effect of emboldening some people to characterise survivors of sexual assault or rape as being blameworthy for not being sufficiently modest or chaste. I share these concerns for women under this proposed law. It makes me feel even more motivated to speak up and defend our Tasmanian laws, which protect women in all these circumstances. The idea of contemplating the withdrawal of that protection for Tasmanian women is something I find quite appalling. I have a high level of concern about provisions of the Religious Discrimination Bill that appear to allow bullying and abusive comments in the workplace, in the classroom, and discrimination in healthcare and in the provision of other services. I believe that most reasonable people would share some measure of concern on this. Mr. President, I'm going to speak to point 7 in the motion. Point 7 asks that the Legislative Council believes that we believe people of faith should be protected from discrimination, as they are under the Tasmanian Anti-Discrimination Act, but does not believe statements that purport to be religious should have special legal status over and above other forms of communication. This proposed federal law includes positive measures to protect against discrimination on the basis of religion, and for these it is to be applauded. Mr President, the Australian Human Rights Commission, among many others, has endorsed those elements of the proposed bill that protect against discrimination on the grounds of religion. The Commission points to a valuable consistency between these proposed protections for religion alongside the existing federal discrimination laws that offer protections for race, sex, disability and age. Indeed, judging by a quick scan of the submissions made and the public comments made by prominent stakeholders, if the proposed federal bill focused only on these elements alone, there would likely be resounding support for its introduction. I heard just yesterday the Federal Attorney-General Christian Porter discussing the proposed legislation on ABC Radio AM program. As part of that discussion, he relayed a story as an illustration of the rationale for this bill and this matter of protecting people on the basis of religion. I'm going to describe the story briefly and I hope it's accurate. It was simply that a Jewish man in New South Wales who was denied access to an event at the New South Wales Parliament on the basis of his religion. And the Attorney-General suggested that this federal law was required to ensure that such discrimination on the basis of religion was not legal and that anyone who experienced such discrimination could have recourse to address it. I think this is a good illustration of what the Australian Human Rights Commission and most of us would agree is a positive reason for the introduction of those aspects of the proposed bill that would indeed provide federal protection and recourse for such situations. We, of course, wouldn't require it here in Tasmania because we're already protected in that way. In fact, the Tasmanian legislation could stand as an exemplar for the federal legislation in order to extend those protections to other parts of the country. Mr President, the proposed bill goes substantially beyond these well-supported elements of protection. The Australian Human Rights Commission also noted and warned against the fact that this proposed bill went further and suggested that the bill contains, and I quote, unique provisions that have no counterpart in other anti-discrimination laws and appear to be designed to address high-profile individual cases. As a matter of principle, the Commission considers that this is not good legislative practice. As a matter of substance, the Commission considers that this may lead to unintended and undesirable consequences. End of quote. International human rights law relies on the concept of equality and non-discrimination. Under international human rights law, freedom of thought, conscience and religion, and freedom of expression are both expressly limited. The limitations on them protect the fundamental rights and freedoms of others, including the right to equality and non-discrimination. Indeed, freedom of expression, or what we would probably generally refer to as free speech, is stated to carry with it special duties and responsibilities to respect the rights of others. No good argument has been made as to why we would treat statements of religious belief differently in the context of freedom of expression. Why we would privilege it above other non-religious statements. It appears to be an attempt to write special rights and privileges into Australian law to make it lawful for people or organisations to say anything they want, as long as it's construed as a religious belief, and regardless of whether it humiliates, intimidates, insults or ridicules a person. Religion plays an important role in our community. It's an important aspect of many people's lives. The right to have a religious faith, to give expression to that faith and to undertake activities relating to that faith is one that I support, but not at the expense of protecting the rights and the safety of others. Mr President, I'm going to speak to point 8 of the motion, which condemns the federal government for its attempt to weaken protections for Tasmanian women, LGBTIQ people, Aboriginal people, ethnic and religious minorities and people with disabilities. Mr President, the word condemn could be regarded as an overly strong word to use in this context. However, I believe its strength is warranted. In its proposed bill, the federal government is attempting to allow some people in our community to say things to other highly vulnerable people that will humiliate them, that will insult them, that will ridicule them, and that will intimidate them. In my view, that is entirely unacceptable. In fact, I find it quite contemptible. At a time that we are, in so many other spheres, so focused on combating bullying and the recognised damage that it causes, including right here in this place with the recent passage of more robust bullying legislation, how can we possibly countenance this appalling backward step in our compassion and humanity? Excuse my presumption, but I'm going to suggest that none of us in this place are likely to bear the full consequences of this federal bill if it is passed. None of us is likely to be told that in our essence we are sinful, that we are an abomination, that we are disgusting, that we are freaks of nature, that we are subhuman, that we are flawed and broken, that we are evil and of the devil, and in our nature a danger to children in the community. Unlike so many Tasmanians with a disability, Tasmanians who are of minority faiths, Aboriginal Tasmanians, LGBTIQ plus Tasmanians, not one of us will have to do anything other than imagine what that must be like, to hear those things said to you. And imagine not just the instances that it might occur to us, but the daily fear and expectation that it may occur at any time in a public place, in the place that you work, where you go to the shop, when you need health care, or when you take your children to childcare. Every day, we can only begin to imagine what it would be like to endure and the toll that this would take on us and our families. For 20 years now, here in our state, previously the most backward on these matters, we have offered our fellow Tasmanians our love and support and, importantly, our legislative protection in the face of such experiences. How dare the federal government attempt to take that away from us? How dare the federal government threaten the protection that we as a community extend to our brothers and sisters, our neighbours and friends, our work colleagues and all our fellow citizens? And how dare we, any of us, fail to stand up, to speak up and to make every effort to defend those protections? Given the gravity of the impact of this proposed bill from the federal government, I choose to use strong terms and express myself strongly in my response. I believe condemn is exactly what is warranted. And that brings me, Mr. President, to the final 2 points of this motion. Number 9 calls on the state government to consult with affected communities so that Tasmanian people who may be negatively impacted by the proposed bill can have their views heard and considered before forming its response.
David's gone home.
Mr. President, I believe that no response has been made formally by our state government in the consultation process on this proposed bill. It may be that the state government is responding through other channels, and if that is the case, I think the Tasmanian community has a right to know what response is being made on their behalf by their state government. Who have the state government consulted with to date as they consider the proposed federal bill? What assessment have they made of its likely impact on our State Act? What processes are they undertaking to arrive at a position on this, and how will they be advocating for that position with their federal counterparts? I believe that Tasmanian people should reasonably expect that their state government would staunchly defend our state laws and the protections provided under them to our community. Under point 10, we call on the state government to defend Tasmanians who are vulnerable to discrimination, hatred and abuse by rejecting the proposed federal bill. Again, I'm going to quote here from Professor Therese Henning, who was speaking last year on the 20th anniversary of our Anti-Discrimination Act. In her speech, she said, "What I have attempted to show in this address is that while our Anti-Discrimination Act is widely accepted and revered as part of the fabric of the Tasmanian justice system and society, we cannot be complacent about it. It is not immune to threats in various guises from those who oppose its application or seek to narrow its protections. Mr. President, our state and our people have the most to lose from this proposed federal bill. We are, in fact, being targeted by it, and the protection of our most vulnerable people is being threatened. This proposed bill should be rejected by all of us, but especially by our state government, as they should be the key defender of our state's sovereignty, defenders of our demonstrably successful and lauded state law, and defenders of the people of Tasmania, most importantly and especially those who face discrimination. I commend this motion to my colleagues in this place and ask them to support it."